thank you for the kind invitation. Yeah, as you may gather, I'm fond of long titles, but the talk will not be quite as long. I'm going to share my presentation now. And for the sake of simplicity and convenience, I've put together these three aspects, which will form parts of my contribution today: museums and access to the public domain, museums and the protection of cultural heritage as a principle that can be an obstacle to open access, but is valued by some institutions, and NFTs and how they are minted by museums, how they fit into this framework of open access, the public domain, and cultural heritage. And we start right away with an instructive case that occurred, a law case that occurred a couple of years ago in Germany, the case of the Reichs-Engelhorn Museums in Mannheim. There, a museum visitor had bought a catalog of works from the museum collections and scanned some of the paintings reproduced in that catalog. He had then uploaded these scans to Wikimedia. In terms of copyright, the works reproduced were safely in the public domain. The scan was free of any rights. However, this middle layer in the copyright sandwich, so to speak, was not free of rights because the German law protected faithful photographic reproductions as non-original photographs. This kind of protection exists in several European jurisdictions, including Austria and Switzerland. At the end of that lawsuit, involving 3 instances of courts, the German Federal Court of Justice, the Bundesgerichtshof, confirmed the judgments, ruling in favor of the museum. This meant that it was illegal to use this reproduction without the museum's consent, a license effectively, in Germany. Under the impression of that decision, the European Directive 2019/790 changed the legal landscape for reproductions of works in the public domain. In Article 14 of that directive, it said that once a work of art had entered the public domain, which in the EU effectively means 70 years after the author's death, reproductions of that work should not or no longer be subject to copyright or related rights unless they were originals in their own right, like artistic photographs of works of art, for example. And this directive has been implemented in the national jurisdictions. I quote here in the presentation the German and Austrian copyright laws. And as a result, the case that I mentioned would be decided differently. Today, the museum can no longer claim image rights for the photographic reproduction, and reproductions of these works in the public domain can circulate freely. These legal developments have helped to make cultural heritage freely accessible and usable. Some pioneering institutions, such as the Rijksmuseum, the Metropolitan Museum of Art, and others who've joined them, the Belvedere in Austria, in fact, and the museums of the city of Paris, for example. The list is getting longer and longer. These institutions have become a normative model, the legal standard. While some of these institutions offer images with no questions asked, just download and have fun, others demand a registration or a statement about the intended use. Nonetheless, one can say that open content and open access mean a loss of control on the side of the museums, which they had before, as that law case has shown. This loss of control also means a liberated market for commercial uses of art. Sometimes these are regarded as an interesting cultural phenomenon in itself, such as at the exhibition of Klimt drawings in 2012. And admittedly, we then bought a Klimt rubber ducky for our kids at the time. And while some uses are generally regarded as fun, others raise questions, such as the reproduction of Vermeer's Girl with the pearl earring on a shoe sole. Here, art is literally trampled underfoot. if reproductions are not controlled, they appear in places that can be deemed as inappropriate for cultural artifacts. The question was put on the agenda last year when a platform offering pornographic content produced short movies adapting well-known paintings from art history and used them as a starting point for sexual activities. The enterprise had read their art history and produced films based on Courbet's Origine du Monde, A Male Nude by Degas, Titian's Venus of Urbino, and others. All these works are safely in the public domain. There are no copyright restrictions on their use. However, the Uffizi, the Prado, and the Louvre were successful in making Pornhub remove the clips based on works in their respective collections, and we'll go into the legal conditions for that. So concluding the first part, we can ascertain that the public domain includes access for commercial purposes. The Pornhub incident was instructive on many levels. It was a reminder that sexual content is a major commercial factor on the internet. It also brought the wish to control the use of art back to light. The protection of cultural heritage is an argument that is brought into the discussion here as a means to legitimize that kind of control. 25 years ago, an article in a legal journal had phrased this as a plot to control art images in the public domain through copyrights in reproductions. The catchy title phrased it as a plot to keep the world safe from naked chicks in art fridge magnets. This relates to the claimed degradation of art through erotic recontextualization that we've just encountered. It also relates to a preoccupation about artistic integrity, perhaps. I'm presenting you a fridge magnet here that I bought several years ago with a cartoon version of Michelangelo that was sold as a Leonardo here, Da Vinci, which is, of course, undermining Michelangelo's artistic integrity here. But maybe they had just the Ninja Turtles in mind. Of course, you can put anything on a fridge magnet. The question is, if it is anybody's business to judge if the work on the magnet is in the public domain. To complicate things further, even non-commercial users of works in the public domain can feel problematic. For example, when extremist political parties use art for their own purposes. When the Rolling Stones protested against the use of their music by Donald Trump, the legal argument is about moral rights of the artists based on copyright. And France, for example, these rights are perpetual. In most other countries, they expire with the general copyright term. And as a result, there is no competent person to manage these artistic integrity rights, although an institution owning that work of art might object to its use. In socialist countries, interestingly, this problem could be solved by letting the state step in once the moral rights of the artist had expired. For example, in the German Democratic Republic, I quote, competent state bodies or institutions had the mission to ensure the protection of the integrity of the work and the preservation of the reputation of its author. The same principle exists outside socialist jurisdictions, for example, in Italy. Here it is not based within copyright law, where it wouldn't have a place because of the European directives that I quoted and the ongoing harmonization of copyright rules. As we've seen, there's an ongoing trend for the easier accessibility of works in the public domain, and the EU understands itself as a supporter of a free European market. Here, the principle is different. It's to be found in the Code of Cultural Heritage, which is part of the administrative law. Any use of reproductions of works deemed to be part of Italian cultural heritage are subject to approval by the cultural authorities, which can be a museum or another public office, archives, for example. Any commercial use involves the payment of fees in advance. And the Tribunale di Firenze, the Court of Florence in particular, has become an active defender of the principle and sentenced several companies over the alleged misuse of Michelangelo's David. While the arms factory was based in Illinois in the United States and thus out of reach of the Italian authorities. Two of the other enterprises were Brioni and the Italian Sculpture Workshop, who had made the replica of the Michelangelo and who had lent it to Brioni for their campaign in 2018. The Italian lawyer Simone Aliprandi has called this a pseudo-copyright, since the effects are very similar. They aim to control the use of images, and this, of course, includes the digital distribution of images. I would like to add that the effects can go even deeper if we disregard the rhetoric of cultural heritage. It is a property right that gives the owning institutions the right to control commercial users and to profit from third-party business initiative. It would be rewarding to go into further detail of these developments. There are more Michelangelo cases, and litigation has been filed by other museums, for example, the Uffizi against Jean-Paul Gaultier. The Italian Code of Cultural Heritage offers some exceptions, such as the free dissemination of images of cultural goods in such a way that they cannot be reproduced further for profit, which sounds good, but raises other questions, because images that are put online with a free, unrestricted access actually can be reproduced for profit. And as we've seen, they will, if popular enough, be reproduced for such purposes. In consequence, it's not that easy for a cultural institution to implement an open content policy under these circumstances. In effect, Italian legislation restrains open content policies and curtails the public domain. I wouldn't want to single out Italian laws here on this occasion. Other countries have similar legal frameworks, and related effects have also been achieved through other legal routes. For example, the Prussian Palaces and Gardens Foundation in Potsdam, Germany, won a court case giving them control over the commercial use of photographs of the palaces and gardens taken on their premises. Note that these buildings are in the public domain, and in the absence of regulations like the Italian Code of Cultural Heritage, the claim here was based on land ownership. Real estate now involved the control of images. In 2021, it was widely noticed when the foundation changed its policy to a more liberal understanding of its property. And that judgment has practical consequences. For example, if we look for images of the Sanssouci Palace in Potsdam at Getty Images, we get 27 hits, all historical images or not showing the buildings. And in comparison, a search for Wiener Hofburg will result in 332 hits that include many displaying the actual architecture. Another practical effect is that stained glass windows, which are legally part of a building, belong to the real estate. So when organizers of a hackathon wanted to include photographs of medieval windows in their program, they needed a commercial license from the local parish church. So we can draw our second conclusion. Protection of cultural heritage serves as an argument to exclude or to control commercial activities. That constellation becomes more interesting when we look at museums' commercial activities. Here we have a T-shirt sold by the very same museum that has interfered at third-party users of its collection. Looking at the design, we are reminded of the fact that beauty is in the eye of the beholder too. So these cultural heritage standards sometimes do not always apply for the institutions that profess them. So what role do NFTs have in these coordinates? The list of institutions that have minted NFTs is too long here, too long to be presented here in its full length. Some have become better known than others that can be related to the popularity of the original or underlying artwork. For example, in the case of, again, Michelangelo Tondo, which was sold in one piece, or the already mentioned Klimt Kiss, which was offered in 10,000 tiles. Beyond the hype, an NFT is based on some fundamental principles of the art market. Perhaps the most important is rarity. Limited editions have always been a way to underline uniqueness and originality, as seen here in etchings from the 19th century. Highly individual impressions undermine the concept of an edition of interchangeable prints. A related strategy is to offer photographs on different papers, different sizes, and different editions, which then reduce the size of an edition, make the product a rarity. Indeed, Stella Rollig has underlined in her introduction that NFTs are not fundamentally different from these strategies. So economically, this is what happens with an NFT. It's making data unique again, which are meant to be shared. A digital reproduction is easily distributable. In fact, as we have seen, so easily that some museums try to implement restrictions. And besides any technical intricacies, an NFT is a way to make data unique again. It's a certificate for a digital reproduction, a data file, guaranteeing the extreme limitation to an edition of one. And that's its main attraction. For non-original art, the question of a corresponding value emerges. Borrowing that terminology and the model of different sorts of capital from Pierre Bourdieu, the price for an NFT is expected to correspond to an amount of cultural capital that can be transferred from the artwork in the museum to the owner or buyer of the NFT, which means that we can expect a Michelangelo, Botticelli, or Leonardo to raise more money than other artists might, and we can expect larger institutions such as the Uffizi and the Belvedere to sell their NFTs more successfully than small local museums. The observation made for artists is also true for institutions. In many cases, NFTs do not create cultural capital, they just distribute existing reputation into another digital marketplace, which leads us to our third conclusion, which sounds very banal in some ways, that NFTs are a commercial activity. And there's no divide here between the market and the museum, which in other instances is a divide. Think of deaccessioning and taking off goods from the market when they enter a museum sphere. They are no longer on the market. Last summer, the Italian government must have come to a similar conclusion when it halted, for the time being, the sales of NFTs linked to works in public museums. There remains the impression that the protection of cultural heritage happened against the institutions who have been trusted to safeguard that very same cultural heritage. There remain, to conclude, some open questions. If we took the public domain seriously, museums should be free to venture into minting NFTs. Of course, no commercial success guaranteed, but would art suffer? Would a free commercial exploitation of the works in the public domain harm the reputation and artistic integrity of the works linked to NFTs? My guess is that not, and that a loss of cultural capital would not affect the works, but rather their host institutions, that is the museums. A consequence of NFT investments is that museums have compromised their moral stance on the commercial monetization of their collections. From the point of view of the protection of cultural heritage, works in public collections should remain withdrawn from the market. Digital doubles undermine these value allocations, which raises the questions about the convertibility of the moral capital of museums, but also whether there are limits of this convertibility set by museum ethics. Is it a case of keeping and eating the cake of art? And that's maybe something to discuss now. Thank you for your attention.